a little bit earlier, just like we did last time. And I'm going to replay the last hearing. So we just get in the mood to be in court today because it's coming up today at 2 p.m. And so what I'm going to do is I'm going to replay a little bit of the last hearing, like I said, to get us in the mood. This is the replay from the last hearing, and at 2 p.m., hopefully we'll be live with Aidan Kearney, Tim Bradle, Mark Betterow in court today at 2 p.m. I'm looking forward to seeing what happens today. This was the last hearing. Let's watch this.
Taking away my advantages here. Sorry.
Turn off your cell phone, please.
For the record, before the court, numbers 4, 5, and 9, Commonwealth versus Aidan Kearney, 23 CR 313, 24 CR 43, and 25 CR 88. Kearney is present. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth.
Good afternoon.
Okay.
Timothy Bradle for the defendant, I bet.
Nice to see you.
Nice to see you.
For the defense.
How are you? I'm Mr.
Judge,
Kearney.
this is my client, Aiden Kearney, in the middle.
Good afternoon. All right. What do we have today?
Well, we have a bit of an agenda here for you, Your Honor.
Go right ahead.
Can I go through?
Yeah, go ahead.
Thank you. Your Honor, we're back here on discovery issues that have been going on. As you know, the automatic discovery certainly is due at or before the pretrial conference, which was like over a year ago. And we've been going back and forth with this. And if you just peruse the docket, I'm not going to go through it because I know these kind of tedious discovery hearings are awful for everybody. But if you peruse the docket, you'll see all kinds of motions to compel. Yeah, sure.
Yeah. Yeah, go ahead, Mr.
Yeah,
Bradle. I'm
thank
sorry.
you.
I left my notes. I took some notes.
No, that's okay. I appreciate you taking.
Yeah, and then I left it in the lobby. So.
We're willing to wait for you, Your Honor.
No, Mr. Summers went to get it. Takes good care of me. Mr. Bradle, go right ahead.
Thank you, Your Honor. So if you peruse the docket, Judge, you'll see all kinds of motions to compel, and it's just not happening. It's just not happening. So putting the issue of, you know, whether it's an intentional thing or a, you know, just not getting it right kind of thing, nonetheless, we need these items. They're exculpatory. You know, if this was just regular discovery, I might ask for a ruling that the Commonwealth may not use certain items they haven't given us, but this is exculpatory stuff that we need. One of the most important highlights, Your Honor.
So I went through it. These
Yeah,
are
go
what
ahead.
my notes are. You want access to different items in a form that you can see on your computer, right?
Right. We can't open what we got.
You want something about somebody that's allegedly a government agent, right?
Yes.
You want digital copies of some documents. You want videos that were taken by the Commonwealth of the rolling rally. The Brady list, right?
Yes.
All right. Is there anything else?
Yes, Your Honor.
Go ahead.
There's a whole host of items.
Yeah, go ahead.
So the first thing, Judge, is that I don't know if you heard, but it was all over the media, but we got 4,000 blank pages after we were here last time when the Commonwealth said, oh, we gave them 5,000 pages. 4,000 were blank. And now the Commonwealth wants us to give back the thumb drive that has some things on it minus the 4,000 pages. So last time we gave something back, we never saw it again, and they still don't want to give it to us. And that's the Gattani extraction.
Yeah, I read that.
The redacted extraction.
There's another motion, a pro se motion on that.
Yeah. So, I'm sorry. Go ahead, Judge.
No, go ahead.
So it's been like 9 months, and we don't have the redacted extraction that the Commonwealth promised me. I look back at my emails on July 9th, 2024, saying it would be ready for pickup. And it just never happened. So now they are apparently doing a 180 in their filing saying, go get it from your friends, Mr. Kearney. And I don't really understand that. I don't think it's a serious response. And the Commonwealth owes us the discovery, the redacted discovery. and I ask that you order that forthwith.
Okay, let me hear from Mr. Cosgrove on that.
All right. Many of these issues, Your Honor, I addressed in my filing. I have been working diligently to get Mr. Bradel the discovery, despite some obstacles. If Your Honor would be kind enough to go through the list that you just went through with Mr. Bradel one by one, I will respond to them individually.
Yeah. The Commonwealth video of the rolling rally?
All right. The Commonwealth has provided at least 2 copies of the video to the rolling rally, one of them in the format specifically requested by Mr. Kearney. The last time it was provided was, I think, about 6 months ago. The first I heard that he was having a problem with it was the motion that he filed on the last date. As I indicated to Your Honor in my filing, I had notified Mr. Bradel of dates that he could come over to the office, and we would attempt to show him the video and resolve that, which was his suggestion in the first place.
Oh, yeah, I remember reading.
And I got no response.
Mr. Bradel, when are you going to go over to see Mr. Cosgrove and
Yeah.
look at this?
So Judge, that's a separate category, okay? I don't think, you know.
Let me start with this. When are you going to go over to Mr.
Yeah, we'll be happy to go over it. We're not concerned with that aspect of it. We're concerned with the stuff that they were supposed to give us. We can put that aside, the stuff that they tried to give us.
Right.
And it didn't work, you know, that it's not the right format. Nobody can open it short of Bill Gates. And, you know, that stuff, I'm confident with our team, there's some really good computer people on our team that can figure it out. And we've said to them, just do this. And they haven't done that. So if we have to go over there,
Mr. Cosgrove has said to you, come to the office.
yeah.
Well, do it.
Yeah, we will, and that's not what this hearing is about as far as we're concerned. There's a ton of other stuff
Okay,
that doesn't require that.
that's fine. Go ahead, Mr. Cosgrove.
And the second item, Your Honor?
Let's see. I have the Brady list.
I had indicated to Mr. Bradel that I would provide that information 30 days before evidentiary hearing or trial, whichever came first.
I think, and then you said you'd give it to him by September 3rd in your memo?
Yes.
I'll order that. I'll order you to give it to him by September 3rd. So that takes care of that.
What's next, Your Honor?
Okay. Let's see. We have, I think we get to then the, supposedly somebody working as a government agent.
Oh, that would be Catherine Peter, I believe.
Yeah. All right. So tell me about that.
Well, Catherine Peter is relevant basically to the Lindsay Gattani cases. She is a former employee, as I understand it, of Mr. Kearney. He and she had a falling out over issues that don't concern the Commonwealth long before this case was originated, and basically exchanged negative posts about one another. From time to time, she has emailed usually Lieutenant Tully.
No, I'm not interested in the specifics, but more so, I think in your filing that I have in front of me, you have replaced the defective thumb drive. Am I correct?
Yes.
Mr. Bradel, do you have that?
We do, Judge.
All right, so then that's taken care of.
Yes.
All right, great. All right, that's good. Provide.
Yes, sir.
Okay. So then we go to the next one. which is a digital copy of all communications from District Attorney Morrissey to civilian witnesses. And it gives a list of names. And then it says that from Mr. Bradel's point of view, that the Commonwealth hasn't provided complete discovery. Go right ahead, Mr. Cosgrove.
Well, I don't know what he thinks he's missing, number one. Number two, what the Commonwealth is obligated to do under the rule is to provide statements of witnesses.
Yeah.
It's not obligated to provide the electronic information which may accompany it, any more than when it turns over a photograph, it's required to provide who the photographer was, that sort of information. I think this information, I have an inquiry in, would be difficult to access and provide. The Commonwealth has spent literally days assembling statements of witnesses, which are voluminous because it includes all kinds of emails that the witnesses have made to the district attorney's office. And those have been harvested by means of an electronic system called ETOS by using term searches. And then people have gone through them and screened them, and I have screened them for compliance with Rule 14, generously construed, and those have been turned over. I can conceive of certain situations where electronic information might be exculpatory, and I think that's an issue that can be raised on a email by email basis. For example, if it were, if you had an email from somebody and their location at the time that they sent the email undid or provided an alibi or something like that, that would be exculpatory. It should be turned over. But in the ordinary course, all this does is provide information to the defendant that is irrelevant and is not required to be turned over. I think these are issues that can wait for a determination as we approach trial as to whether something is material and admissible.
Okay. Mr. Bradel, can you comment on that?
Yes, Judge. So this is a metadata issue?
This is the individual, well, it's a digital copy of all communications from District Attorney Morrissey to civilian witnesses.
Oh, yes. Okay. Thank you, Your Honor.
And it lists a whole slew of people.
Sure. So, Judge, the Commonwealth in this case has been going to the mattresses, so to speak, to keep this stuff from us. And meanwhile, the employer of the special prosecutor has released a FOIA of these items, which, just to move ahead for a sec, the fact that they released all this stuff pretty much obliterates this Commonwealth's impoundment privacy argument. But while we've been going back and forth with all this court time with keeping things secret from the defense here, the district attorney's office released 4,000 text messages from Trooper Tully as a FOIA request to the general public, while we, as defendants in a criminal matter with constitutional rights attached, have got nothing. So it's out there, this FOIA request from the employer of the special prosecutor, but not from this special prosecutor. So in terms of the integrity of this stuff, we need the special prosecutor here to give us the items in the context of this case.
The 4,000 text messages, were they related to this case, Mr. Bradel, or related to other cases?
Well, it's relevant to the Read matter, to our matter, it's all the same alleged victims. It's actually emails, not text messages. Okay. Sorry. But it's 4,000 pages of stuff that we've been wrangling back and forth about. Meanwhile, the district attorney's office releases them in a FOIA like a week ago. That has been bandied all over media while we've been trying to get this stuff for a long time.
Okay. Let me
so yes, it's a good thing that we're getting it.
Yeah.
but we need the government, in this case, to give us what they are contending is that stuff.
Let me just go to Mr. Cosgrove for a minute. Mr. Cosgrove, were you aware of that?
The short answer is no.
Yeah.
It's, I guess, part of the price of having an independent special prosecutor, Your Honor. I don't work out of the office. I haven't been to the office within the last 2 weeks, I think. So I was not aware of that. I was aware that 12 news organizations had filed FOIA requests for information in the Kearney and Read case.
Sure.
But I wasn't aware of what particularly had been released. I'll look into that.
Okay.
I will say that when Mr. Bradel says he's received nothing, that is flatly untrue.
Okay. All right.
I agree, Judge. We got about 200 and something pages out of what was supposed to be 5,000.
So I remember the last time we were here, Mr. Cosgrove, you had said that there were 5,000 pages or some large amount of pages. I'm not going to say 5. It might have been 3.
It was about 5,000. I think it was 4,700 and something.
Okay. Was some of that blank or?
Well, the only information I have with respect to that was a letter from Mr. Bedrow that arrived 5 days later complaining that the bulk of those pages were blank. I do not know why they would be. I haven't been able to figure out why they would be. As a result of that letter, I went back to the DA's office and sat down with one of their electronics people and had them make an entire new copy off of my laptop. And I actually added a little material that had come in since, provided by one of the prosecutors in the Read case. But the bulk of it was the same 5,000 pages. I then went through that personally with the electronics person sitting by my side and ensured that each and every page was reproduced on the copy that I sent to the defendant. So,
have you sent that to Mr. Bradel or Mr. Bedrow?
I've sent it to Mr. Bradel, and I'm informed that he's got it, so I'm not quite sure why we're still talking about it.
Got it.
Got it?
Got it yesterday, Judge.
All right.
So haven't been able to go fully through it.
Yeah, no, sure.
It supports all sorts of other things that we're here for as well.
All right. But you did get it. Okay.
Yes.
All right. Then the next thing would be, the next thing I see, and Mr. Bradel didn't think this was much of an issue, was the video of the Commonwealth surveillance from the rolling rally. Has that been?
I think we addressed that, Your Honor.
We can go to the office, and I'm sure that.
Yeah, okay, so that's fine. So that takes care of that, that's
Thank
good.
you.
And then,
Judge, before we move on, I don't want you to go too far off of this. So I know it's tempting to think that these 4,000 blank pages is the same thing as the 4,000 FOIA. They're different. So the first thumb drive thing with the 4,000 blank pages has been remedied, okay? But the FOIA thing that should have been given to us has never been given to us, but they're responding to FOIAs about it to everybody but Mr. Kearney. So
I get that, but Mr. Cosgrove says he's gonna look into that, and I'm sure he'll give it to you.
Okay, so I just didn't want you to think that was the same.
No,
4,000.
No, I
Coincidentally,
didn't
it's
think
different.
that. Yeah, I didn't think that.
Okay.
All right, I didn't think that. All right. Then I think it's just am I correct, Mr. Bradel? Is that the list, or are there more?
There is more, Judge.
Yeah, tell me the rest.
All
Go
right,
ahead.
sure. So within the thumb drive, the thumb drive that was just remedied and given to us, there's all sorts of attachments, and we have a disagreement about this. There's all sorts of attachments from Ms. Peter to the state trooper team and Mr. Mello, I believe it was. I don't think Mr. Cosgrove was on the case then, where Ms. Peter is repeatedly providing attachments of things to the state troopers, and she's literally working on videos for the state troopers that were exhibits in the grand jury.
Let me just hold on for a second. Yep. Mr. Cosgrove, is that part of the 5,000 pages?
Yes.
All right, so then there, you go, you got it at least.
I wish I could say we did have it.
Yeah.
If you hit the attachment, you get that message saying nothing's there. I printed out a few of them, but I'm sure you can just take my word for it, Judge. It says no attachment, nothing found, et cetera, et cetera. They don't come up.
So that's a technical issue. I'm sure you can figure that out.
So I think it's worse. I think it's
Hey,
I think
Chris.
it's actually a lot. Sorry, Judge. I
Yeah,
think
just,
Again, he says you are good to go.
Yes. All right. I'll see you shortly.
Okay.
Thank you very much. See you in a minute. Thanks.
Thank you.
Bye.
Bye-bye.
hi,
So, Your Honor, it's actually,
when does the Zoom?
yeah, it's actually a lost evidence issue, Your Honor. It's not a, oh, gee, we can't open it issue.
Yeah.
It's gone. I think they lost the evidence. And for whatever reason, the attachment has been taken away on the other end, okay? So this is a real bit of prejudice and a distinct bit of harm to the defense that Ms. Peter, who is a government agent, who's provided, and we'll get to this.
Let me just
False
ask Mr. Cosgrove before you go into all of that.
Sure.
Mr. Cosgrove, to the best of your knowledge, has that been turned over to Mr. Bradle and Mr. Betterow?
Has what been turned over?
Has any of the attachments that Mr. Bradle has just referred to?
Depending on what the attachment is, some of the attachments are visible simply by clicking on it. Others that specifically Mr. Betterow has inquired about, to the extent that I can resurrect them, I have sent them along to him and will continue to do that. I haven't worked my way entirely through his letter. But what happened, Your Honor, is this. Lieutenant Tully, who was the recipient of most of these, has the practice of not clicking on unsolicited links that are sent to him on email, so he doesn't access them. Now, if someone is sending him a reference to something that is online, he may check with that person and ask the person, where can I find it online? And then he will go himself and look for it online. For example, Mr. Kearney's YouTube presentations that were introduced to the grand jury. All of those were things that Lieutenant Tully found himself online. He may have been pointed to them by Ms. Peter. He may have been pointed to them by one of the alleged victims who complained about them. May have been pointed to them by multiple sources. But he never clicked on whatever it was that was sent, in part because he's working off a computer system, an office computer system, and there's caution about infecting it with unsolicited links. So these were never accessed, in effect, by the Commonwealth. If the links are now dead, we've never seen them. The links are dead presumably because whoever sent them took them off the internet. So
This would be some text from somebody with a link to a video or something else. And so you'd have the text, but not what the attachment is?
you'd have the text, you'd have a link to a video.
I get it. Okay.
You click on the link now and
Yeah.
nothing happens. Whether if Lieutenant Tully had clicked on the link
Right.
6 months or a year or 18 months, it would have taken him somewhere. Probably would, but he didn't.
Okay. Gotcha. All right. Mr. Bradle.
A couple of things, Your
Go
Honor.
ahead.
Bit of a red herring to kind of suggest that, oh, some crazy person from the internet is sending me something and I don't want to look at it. That's not this. This is a government agent, Catherine Peter, sending them stuff that she's working with them. And you know, you mentioned an evidentiary hearing the other day, Judge. I think we should have an evidentiary hearing on this discovery stuff. Let's bring in Mrs. Peter and let's find this stuff, because this is important stuff, and I'll tell you why in a second. But this isn't some unknown person. This is someone who repeatedly emails the state police and Mr. Mello, so in other words, and the government and the prosecution and the Commonwealth, and is actively assisting the Commonwealth, providing links to certain things. So they're gone. And so let me just jump ahead. One of the things that's missing is Ms. Peter, and we know this from the new emails that we got last night. Ms. Peter changed the titles of Mr. Kearney's shows that were these 4-hour shows, Your Honor, that had innocent titles, like, you know, for example, Kearney and Read case, where's Michael Proctor? Amiri King wants to fight Turtleboy, Canton updates, anti-Bev Cannoni out of control. So it's a title that encapsulates a 4-hour show. That was his work. Ms. Peter changed those titles, provided it to the Commonwealth, told Lieutenant Tully in the emails that we have about changing the title, so they knew. And then they put those titles in as exhibits. We found this out, of course, after the McCarthy-Odell motion. And these titles are different. These titles are very incriminatory, and they suggest they impact Mr. Kearney's alleged intent to intimidate witnesses. The titles were all changed, and I can proffer up a spreadsheet of the actual titles and then what she changed them to in these attachments that, oh, gee, now we can't open them. So do the math on that, if I may approach, John.
Yeah, sure. Thanks, John.
And so we have now learned that we have a grand jury that was listening to these video clips with titles like, you know, I'm going to kick Colin Albert's ass. And that's just me paraphrasing, but nasty titles. Give me another copy of this one. Yeah. Trying to destroy Colin's life. The actual title is Commonwealth tells more lies about John O'Keefe's GPS data. That's his real title. And these were suggested to be Mr. Kearney's expressions, which of course would be used as his bad intent. And they're false and they're lies, and they were done, and we know this from the emails, from this Catherine Peter person.
Yeah, but so what does this have to do with?
So these are attachments that we can't open. There's an example of attachments that are exculpatory and incriminatory to the Commonwealth that we can't even open. So
these YouTube, so on the side of the document where it has the link, your allegation is that you can't open up any of these.
No, I'm sorry. That's if you wanted to see for yourself. But the other two columns are what Ms. Peter made those titles.
Yeah, no, I get that.
And then the regular title.
She changed.
And that was used.
This document, she changes.
That was published to the grand jury as Mr. Kearney's work. And it was even argued in Mr. Cosgrove's, one of his recent filings, he argued that, about how these things are so aptly titled, is what he wrote. You may remember that. And this is all false evidence.
Okay.
So, you know, this is
looking for us to do with it, though.
I'm looking to ask to take you up on your offer to have a hearing on an evidentiary hearing where we bring these people in and we get to the bottom of how Ms. Peters' work for the Commonwealth went. And that also impacts, and see, this is all interrelated, Judge. We want Attorney Mello on the stand for this too, because he's the one that presented this false evidence to the grand jury.
I'll take a look at whatever you file, but I think we're kind of getting off track a little bit in terms of what the Commonwealth owes you. That's what I'm concerned.
Okay, I know, I hear what you're saying on that issue, but we did file a motion to disqualify Mello, who's been, you know, not able allegedly to be here, but he can be on Zoom. Whenever there's a hearing where Mr. Kearney's bail might get revoked, he's right on the Zoom watching. But, you know, that's another thing we'd like to do here today is ask the court to schedule an evidentiary hearing.
I'm gonna write a motion.
No, we did, Judge, I filed two.
For an evidentiary hearing? Is there a new one?
Yes, on motion to disqualify. We have two pending. In fact, Judge Rayburn, I believe it was, set the hearing, and he was he alleged that he was sick and couldn't come, and it's been in abeyance forever. So we have, Judge. I don't want to, bury the
talk to you, Mr. Cosgrove.
Sure. So you see, Judge, how everything's interrelated. And with respect to the disqualification issue, this is another issue where Mello's involved in this, what we would contend is a conspiracy to put false evidence in front of the grand jury that we figured out. And it was used and argued it was a misrepresentation of Mr. Kearney's intent. Because when you would put a title like that on something.
So this is what I'm trying to get you back to, though, Mr.
All right, go ahead, Judge.
What do you need? What else do you say that Mr. Cosgrove has as the special prosecutor that he hasn't turned over to you? We went through that list of items. I just want to get you back on track.
Sure, okay. So, Judge, there's a November 1st email that we can't get the links off of that, and that's important. If I could just have one moment.
Yeah.
And that's the exact email with the links to this, fake links to this that we can't open. And it's not a thing like, it's not a thing where, oh, well, let's go back to the office and fix it. It literally says, Google Docs, it says, sorry, the file you have requested does not exist. So it's gone.
Okay.
So why did this person make it go away? And I think we know why, but that's why I want to ask you for that hearing too. But so we want the government to, in writing, tell us what links they have and what links, where did they go? We want them to respond in writing to why there's lost evidence.
Okay, let me just talk to Mr.
They have what we have, and they can figure out where they went to the same extent that the Commonwealth can. The Commonwealth has not deleted any links.
All right, I'll take that under advisement. What else you got?
It says, Judge, literally, the files have been deleted.
Okay.
It doesn't say they've been deleted by the Commonwealth.
So would the court consider ordering the Commonwealth to, we'll tell them what links we can't open, and they need to give some sort of an explanation why this is lost evidence.
Why don't you give us a list of the links that can't be opened?
All right, thank you.
And send it to Mr. Cosgrove. And Mr. Cosgrove, but just ask perhaps if you give us an explanation as to why they can't be opened.
Sure, I will give you an explanation. I will consult with our experts,
Yeah.
but I can almost guarantee, Your Honor, that the explanation is going to be that whoever is at the other end of the link removed the content.
That very well might be it, but I think it would, if it was in writing, it would probably be the best.
Yeah, I'm happy to do that, Your Honor.
That's great. What else, Mr. Brady? What else?
So, Judge, we talked about the Kearney redacted extraction, excuse me. So can I get a copy of that? We don't have it. We've been looking for it for 9 months. Can you order?
What is it, the redacted?
The redacted extraction.
Okay.
Of her phone.
But you had the document at one point in time.
We had it. Judge Krupp ordered us to destroy it and give it back, which we did.
Yeah.
And just 9 months ago, we never got it back.
The redaction back.
Right.
Okay. Mr. Cosgrove.
I object.
Okay. Tell me why.
Well, there's a long history on this, Your Honor, and I went into it in one of my memoranda at length. In the original course, the Commonwealth and the defense entered into an agreement that they would return the original extraction and that we would provide them with a redacted version limited to those things that we felt they were entitled to under Rule 14. I asked Lieutenant Tully to prepare that. He did that. I sent Mr. Bradel a notice. I don't recall when, but the date is in my memorandum saying it's available at the office. Come over, pick it up, or let us know how you want to get it. And I believe I also indicated that there was some additional material on the thumb drive with that extraction. Mr. Bradel never picked it up. In the meantime, came back to court for various reasons that are, I believe, still presently impounded, although I believe Mr. Kearney referred to them on one of his YouTube shows. For various reasons, Mr. Bradel indicated that he needed to keep the original thumb drive. Those reasons were unrelated to any issues in this case, but I was persuaded that he should be able to do that at least temporarily. We struck an agreement with respect to the use of that thumb drive, and there was a subsequent reduction of that or a modification of that to writing at Mr. Bradel's request that was endorsed by the court. And then in the Commonwealth's view, which the defense, I believe, still disputes, Mr. Kearney immediately went out and violated those restrictions. So I then filed a motion in front of Judge Krupp requesting an order that the thumb drive be returned. Now, at that point, Your Honor, the defense had the full unredacted thumb drive in its possession, custody, and control for some 9 months. Mr. Kearney had publicly stated on his YouTube presentations that he had provided the contents, a duplicate of the contents of that thumb drive to any number of other people. But the physical thumb drive was ordered returned by Judge Krupp, and it was returned. In the meantime, the defendant had been presenting what I would consider to be various material irrelevant to the case, designed to embarrass and humiliate Ms. Kearney. There was a reference, for example, to her DoorDash orders. There was the defendant picking out a phone number more or less at random and said, well, here's a number that she apparently calls a lot. Let's see who this is, and calling out the number live and dialing it live on his YouTube show. There was a reference to her ex-husband's daughters, if I have it correctly, and what they thought of Ms. Kearney, and so forth and so on. Judge Krupp allowed that motion at a provision that I agreed to, but I think was initially suggested by Mr. Bradel. The defense was allowed 2 weeks before they turned the thumb drive over, or approximately that amount, to take notes on anything they thought was relevant on the thumb drive, and then it was returned. As far as I'm concerned, they had it. They had an opportunity to examine it. I assume they did examine it. If they have time to go into the kind of trivia and side roads that Mr. Kearney went on to. I don't think at this point that the Commonwealth has an obligation to jump through further hoops and reprovide them with a different version.
All right, I'll take that under advisement.
May I be heard on that, sir?
I think you already were. But I'll give you 30 seconds. Go ahead.
Yeah, Judge, there's no violation. If there was a violation by my client, I say bring it on. There's never been an allegation of a violation. If there was a violation, you know this Commonwealth would have done something about it. There was never a violation. They agreed to give it back. We don't have it. We were allowed to take note of it, but we were ordered by Judge Krupp to destroy it and not have any of it until we got the redacted one back.
Let me ask you this. Did you have it for 9 months?
Yes.
Thereabouts?
Yes.
Did you have a chance to look at it?
Yes, we looked at it, but we were told to destroy it. We don't have any evidence from it. It's destroyed. We were told, ordered by Judge Krupp to destroy it. We need another copy of it. We need the extracted copy of
You
it.
need the
Right.
redacted copy.
Hey, we're happy to take the redacted copy, of
That's fine.
course.
All right, under advisement.
All
What
right,
else you
thank
got, Mr. Bradle?
Judge, so just have one moment, please.
Yeah, no, take your time.
Judge, impoundment. As I alluded to earlier, the fact that the sovereign of the special prosecutor here has already released much of the items the government here is trying to keep private, I think it's completely.
Are these impounded or under a protective order?
Judge, I would say that I don't think it matters, Judge.
I think legally it does, doesn't it?
Well, it's a similar examination, Judge, okay? It's a protective order. Things are impounded by either a judicial order keeping judicial documents private, or you could say, and I think the parlance is that if something is under a protective order, it's impounded from view from people.
Right.
So I think it's just sort of a parlance issue. I think, frankly, the government was splitting hairs when it was trying to say
But
that.
you have all the documents, right? Everything that's under a protective order, you have as Mr. Kearney's lawyer.
Judge, we have, to last time, you know, we're sort of under the gun of having to agree to it to get them, and we need these documents. So, at the time, but this is a serious deprivation of the public's rights to know, Judge. The public is the victim here. And, you know, these are documents that are kept private for no good reason. Whether it's, you want to call it an impoundment or a protective order, there's no legal basis for it, Your Honor. As I said last time, things that show government malfeasance.
What's the basis for a protective order, though? We were discussing that today. Do you have any case law that you could point to on exactly what it is that the government, the hoops that they have to jump through to get a protective order?
Judge, I filed 8 pages on it last time.
Yeah, but what's give me some of the cases that you think are the most important. Because that was actually something we were working on today, trying to.
Well, Judge, the first order of business on that is that the burden's on the Commonwealth here.
Yeah, no, I agree.
So,
I agree.
you know,
Maybe I should ask that question to Mr. Cosgrove. But I'll ask it to you first, and then I'll go to Mr. Cosgrove, because the burden is on the Commonwealth. I agree with that. But these protective orders are already in place. So I understand you have the constitutional argument that you and Mr. Betterow have profit about the public's right to know. I get that part. But just in terms of a practical.
Thank you.
Yeah.
1 second, please, Your Honor.
Yeah. No, take your time.
So, Judge, paragraph 3 of my filing last time, Aiden Kearney's motion to release case documents from impoundment. Paragraph 3, New England Internet Cafe, LLC versus Clerk of Superior Court, Suffolk County, 462 Mass 76. Public has a right of access to judicial documents and a right to understand and observe the operation and work of the judicial branch. They're presumptively public documents. There's a common law right of access to judicial records. So that's sort of that's where we start, is that these records need to be in the public's view. And so the burden is on the government to say why. And then just to carry through, just going to allude to what I said last time, is that when there's corruption or malfeasance, embarrassment, that's not a reason to hide documents from the public. That's a reason to show the documents to the public of the government's missteps. And in this case, there's been a lot of them. And that's really what the government is saying, like, oh, we can't have Mr. Proctor's emails because there's a safety issue. You know, there's always a safety issue. It's either children or a safety issue. There's no safety issue. There's no children involved. It's just embarrassment. He's well on record to show all sorts of horrible things that he's said in his texts or emails or wherever. But so the idea that we're going to hide any more of it is ridiculous. And the other issue, Judge, is that of the ones that we get, there's never the full story. There's like one screenshot of someone's text, and then there's no responses. There's no, you know, there's just a one little thing that they hope we're going to look at and be satisfied with. There's never any context to this stuff. So that's another discovery aspect.
Let me give the floor to Mr. Cosgrove then about the protective orders. I agree with your filings, Mr. Cosgrove, that these are protective orders as opposed to impounded. So I'll start with that.
All right, Your Honor, and let me just say, as I previously indicated, the release of certain public records is new to me. If Mr. Bradel wants to go through the public records that were released and compare them with the material that is presently under protective order and identify any of those particular things, I'm happy to assent to their release from the protective order, because obviously if they're out there, they're out there, and the protective order isn't really serving any purpose as to those particular materials. Now, with that said, in terms of cases, Your Honor, I would direct Your Honor's attention to the case law in particular cited on page 2 and 3 of my brief that talks about the validity of discovery orders in terms of discovery protective orders as opposed to things that are actually documents filed with the court. I think that's the pertinent case law to direct you to.
Okay.
I would also, Your Honor, like to direct you, if I could, to a YouTube presentation, which is essentially a commentary on the opposition I filed. Mr. Kearney did about an hour and 10 minutes of his own commentary on my filing. It's in YouTube episode 795, entitled, and I'll leave it to the defense to correct me if I get the title wrong, Cosgrove Gets Frisky, What Happened on the Cape, Twitter Shenanigans. And if you start at about 141 at that presentation, and if you can stand it, Your Honor, follow through to about 350, you'll hear Mr. Kearney's explanation as to what he wants these matters released for. I would characterize his comments somewhat tendentiously as saying, apart from some quibbles about whether I got the titles of his YouTube shows correctly, Mr. Kearney's response is, everything Cosgrove says I want to do with these documents is exactly what I want to do, and so what?
Okay.
Well, Judge, if you look at my filing, there's about 35 cases in there that talk about all this stuff dead on point. And there's no Turtleboy exception to the First Amendment, okay? Everybody out there has got this stuff, and Mr. Kearney is not allowed to look at it or use it. It's ridiculous. Every journalist on Twitter is citing this stuff, and he's got to sit here. The guy that broke half of the stuff in the Kearney and Read case, he's got to sit here and not touch it and not do anything. It's ridiculous. It's totally abhorrent. And
so these 400 things that were released on the FOIA request.
4,000.
4,000. 4,000. Oh. Do you have a copy of those?
Everybody's got a copy of those.
Yeah.
I don't have a copy, Your Honor, but I assume I could get it.
I'm not surprised.
All right. Perhaps, I know it's voluminous, but...
We can give you a link, Judge. It's easy. It's nothing.
Okay.
You'd like a link?
Yeah, that's fine. If you could just maybe write it out.
No problem.
All right. Do we have anything else?
We do, Judge. I'm sorry.
What else we got?
A lot here today.
I just would like to make one more submission.
Yeah, go right ahead.
With respect to the issue that we're
Yeah.
on. One of the points that I made, Your Honor, in my memorandum is that there's a cycle here, which is that Mr. Kearney continues to post things about the witnesses in his case and the Karen Read case on a regular basis. That provokes typically the witnesses to complain to the district attorney's office. That generates statements which need to be turned over in discovery. And I made the point that turning over much of this material, I don't know what public interest there is, for example, in an email where someone says she received an anonymous threatening phone call, which she attributes to a Kearney post, whether rightly or wrongly, other than to, I just don't know what the public interest is in that kind of thing. The public does not have an interest in going through everybody's cell phone, underwear drawer, et cetera, et cetera. So just to drive home the point that Mr. Kearney is continuing on a almost daily basis to publish tendentious commentary about these people, I want to call to Your Honor's attention something that came to my attention this morning that he posted 24 hours ago. If I could.
Yeah, let me take a look at it. Thank you.
I think he missed a few of his usual targets, but most of them are there. I'm not suggesting that this is a violation. I'm not suggesting that it's criminally actionable. I am suggesting that it would help Your Honor conceptualize the use that he's going to make to any of this material that's under protective order.
Okay. I looked at it. I get the point.
All right, that's all I have, Your Honor.
All right. Mr. Berto, what else you got?
Judge, I can, just watching you peruse Mr. Kearney's publications, okay? Thomas Paine, Samuel Adams, Mark Twain would be spinning their graves if they saw that a judge was looking at First Amendment protected satire, jokes, criticism, as if there's some risk that this stuff should be sanctionable. It's just completely antithetical to the First Amendment, Your Honor.
Okay, I don't want Mark Twain to feel poorly about me.
Really?
So,
It's just ridiculous that the government, you know, proffers that as some sort of evidence of something is just completely beyond the pale, okay? This is all First Amendment protected.
I get your point. I get your point.
So
You've made it very well.
So there's a few more things, Judge, about this impounding these.
The impoundment I get. So I get your arguments on that.
One little
Do you have
fact.
any other discovery issues?
Yes.
What else you
Give
got?
you one quick fact.
Yeah.
These people that the government is trying to protect with these impoundment orders that they need, or protective orders, they're doing interviews. The McCabe, the Alberts, Proctor, they've all done nationwide interviews. And yet the government wants to say, oh, we need to protect them from safety because of keep their stuff private. They're doing interviews. So that ship has sailed, Your Honor. All of their stuff needs to be unimpounded for our use, for our ability to use it without these constraints, and for the public's right to know, Judge. It just needs to be out there. There's no reason to keep it.
No, I get your point. All right. Is there any other pieces of discovery that
Yes, Judge.
you want to argue about? Because I have I got some other things we have to do, some other cases. We have 2 other cases left. Mr. Bradle, I don't want to rush you, but,
Just
go ahead.
going back to the Mello issue, Judge. So Prosecutor Mello was the one that was working with Ms. Peter on these phony clips. And we need his emails too on this stuff. And I hope you're not going to say, oh, okay, file a Rule 17. Because I did that with respect to Morrissey's emails. And I was told by Judge Krupp, and I think it's the law of the case now, that no, that's a Rule 14 issue because it's in the possession of the prosecuting authority. So it should be Rule 14 discovery that Mello is communicating with Kate Peter, and it's been undisputed and it's been revealed in this case 100% that Mello has been talking on the phone with the other complainant here, Gattani, and we have only incomplete screenshots and inconsistent screenshots with respect to what's on the phones versus what really happened. And we need a written explanation from the government as to why there's inconsistencies in the discovery, and I'll tell you what that is in a second. But also, we need the full text report. We have these cherry-picked little texts. And like I said before, it's obvious that it was a string, and we get like one email with no responses or no prior context. And it's like they're hoping we just go away if they give us one thing. But it's not, the context isn't there, the full email strings aren't there. And we've made this complaint many times and it doesn't go anywhere. So I'd ask that you order the Commonwealth to either give us the stuff.
This is from the last hearing. Let's see what's going on. If we can get this up in the courtroom. Hold on. This is it. I think this is it. Hopefully we have the right courtroom up.
We are on Zoom. Nope. No, I guess. Yeah. Okay.
And see if we all have the same courtroom and check the emails. I'll be right back. I'm going to leave this on for a few minutes. Hopefully this is the right one. If it is, I won't be back until after. We're going to have someone outside after court too, streaming live here. So
do you have his email?
We'll be back.
Yeah, we could email him.
I'll leave this up for now.
Good afternoon, Your Honor.
Good afternoon.
We do not have a resolution.
Okay.
Chief Rose is going to go.
Why don't we start going down the list and see what we've got?
We are going to start. So numbers 4, 5, and 15 are Commonwealth versus Aiden Kearney, 23 CR 313, 24 CR 43, 25 CR 88. The parties are in the building and.
Do they need a minute, Tim? Yeah, give them a minute. Give them some time to talk.
Okay. Next, for the court number 6, Commonwealth versus Stephen Durant, 24 CR 68. Mr. Durant is present. I have not seen his attorney, Anthony Ellison, yet. The Commonwealth is represented by Assistant District Attorney Amanda Mullaney. The matter was scheduled for a hearing on a motion to suppress. If the parties could please identify themselves for the record.
Amanda Mullaney for the Commonwealth, Your Honor. Good afternoon again.
Mr. Durant, have you seen Mr. Ellison?
Oh, no, I haven't seen him today.
Want to give him a call and tell him that we all say hello?
Okay.
Thank you.
I'll call him right now.
All right, you go do that. All right.
Second call on Mr. Durant. Next is for the court number 7, Commonwealth versus Joe Su, 24 CR 156. Mr. Su, I don't believe is present, neither is his attorney Bradford Stanton, because and she is here. Oh, my apologies. And so she is present. We are joined by Amanda, an interpreter, but we are waiting on attorney Stanton.
Okay. Have you talked to Mr. Stanton?
I haven't. I just sent him a message.
Okay, that's good. Thanks.
Okay, 8 and 9 we already handled. Next before the court, number 10, Commonwealth versus Miguel Febo, 25 CR 34. Mr. Febo is in custody, represented by attorney Billy Keefe, who I have not seen. ADA Stephen Coleman is present. The matter is scheduled
Hi,
for
Mr. Coleman.
change of plea. We're also waiting on a Spanish interpreter on that, I think.
All right. When he gets here, we'll do it.
I'm not sure it's gonna happen today, I just don't know, I haven't talked to him. But if it is,
We'll see.
we'll see. Thank you, Your Honor.
And I think actually we do have one we can do. Number 12, Commonwealth versus Tyrell Williams, 25 CR 75. Mr. Williams
In custody.
is in custody, I believe?
I don't think he's.
Oh, but not,
He's not here?
okay, not present. Represented by attorney Robert Nelson. The Commonwealth is represented by Assistant District Attorney Christopher Cook. The matter is on for pretrial hearing. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Chris Cook for the Commonwealth.
Hi, Mr. Cook.
Robert Nelson for Mr. Williams.
Hi, Mr. Nelson. Tell me what's going on with this.
So, I believe I have all the discovery now, so I was just gonna ask for a motion filing date.
Why don't you come over and talk?
So do we want to pick, like a motion filing date, and then if you talk to your client, we can bring it forward?
Yeah, why don't we do that?
Discussed, I believe, the 27th of October, Monday.
Just saying, you're gonna be in the second session, so, that works. So as to Mr. Williams, the matter is continued to October 27th at 2 p.m. for filing and motion. Thank
Okay.
you.
Thank you.
Okay.
Call, what's it, Johnson and Johnson?
Okay, are they all here?
I don't know, what else do we have?
Are they ready on?
Now, let's see if we can move some of this other stuff.
Okay. Do we have, I just,
Anybody else have anything that they're ready on before we launch into something? Has anybody seen Bill Keys? All right, okay,
where?
away we go.
Numbers 4, 5, and 15, Commonwealth versus Aiden Kearney, 23 CR 313, 24 CR 43, and 25 CR 88. If the parties could please come forward and identify yourselves for the record.
Mr. Cosgrove, Mr. Kearney, how are you? All right, we have Robert Cosgrove representing the prosecution, at least for the moment. We have Jim Bradle, who's here, Mr. Betterow from New York, and we have Mr. Kearney. Before us on the one of the cases, I know you moved to withdraw, Mr. Cosgrove. Which one is that?
I'm sorry, I didn't hear the very last thing.
Yeah,
Your
you
Honor
moved
said.
to withdraw on 240043?
Yes.
No objection, Your Honor.
All right. So on 240043, based on representations, Mr. Cosgrove is allowed to withdraw. Now, Mr. Cosgrove, have you had any communication with the Norfolk DA's office on who's going to take that case over?
I have, Your Honor. My present understanding is that no decisions have been made.
There was another motion to withdraw I saw from another name I was unfamiliar with. Was that Mr. Mello's partner?
Novak, Your Honor.
Mr. Novak, who I haven't seen during any time that I've been involved in the case.
Mr. Novak, Your Honor, is a gentleman who I believe filled in, I'm not sure I have this right, but this is my recollection, filled in for Mr. Mello on one day when he was ill, I think before the grand jury, and entered an appearance for that reason. He's had for involvement with the case. I think it was just a matter of cleaning up the docket.
Helping out Mr. Mello. So I obviously, pursuant to the motion to disqualify Mr. Mello that I allowed, I'll let Mr. Novak out of the case. So, Mr. Cosgrove, I trust that you'll have communication with the Norfolk DA's office about a new prosecutor coming in on 240043. That's the domestic allegation.
They are aware of it, Your Honor. I think as I'm about to leave the case, it ceases to be my problem, if I can be so blunt. But
you can be so blunt.
Someone, I'm sure, will be in touch with the court.
All right. I'd call upon the Norfolk DA's office to see if they can have somebody appointed on that case.
Yes.
And do it forthwith. I'll make an order to that effect.
All right. I understand, Your Honor. I will just say that since, as you are probably aware, the reason for my withdrawal is that the alleged victim in the case is attempting to implead me in a civil suit between her and Mr. Kearney in the Worcester Superior Court. The situation does not seem to me personally, and I'm not speaking for the office, conducive to enticing the special prosecutor to assume my position. So I will have to see what develops.
Okay. I'll make an order, Margaret, just as to 240043, the order of the court that the district attorney appoint the special prosecutor within 30 days.
Judge, if I may, we'd just like to be heard on that very point.
Yeah, go ahead.
Attorney Better is going to address that, Judge, just in terms of the potential conflict extending all the way to the DA.
All right, go ahead, Mr. Better.
Judge, the problem with this situation is that the alleged victim, who is dragging Mr. Cosgrove as Detective Lieutenant Tully, as part of these series of legal maneuvers, sent a demand letter to Michael Morrissey in his capacity as district attorney, presenting claims against the DA's office arising out of the same incidents which have left Mr. Cosgrove to leave. And it's a classic demand letter. If something's not done within 6 months, she intends to take legal action.
And this is to the Norfolk DA.
This is to Michael Morrissey in his capacity as district attorney, and we believe that the Norfolk DA's office now has an irreconcilable conflict because it would lead to questions about how are they in a position as a future potential litigant to start appointing people. So
why don't you do this? Why don't you write up something and put something in writing to show your opposition? Obviously, I'm not going to. I think it makes sense for the district attorney's office to review whatever it is that you file and then make a decision.
Okay.
On that. Okay.
The last concern with that is at the moment, because Your Honor disqualified Mr. Mello recently in the decision. Mr. Cosgrove has been relieved, and this Mr. Novak has been relieved. This case The 24 indictment at this point in time is essentially stateless. There is literally, and I want to overuse the word literally, there is literally no prosecutor on that case for an indictment that is approaching a year and a half, almost 2 years old. There are still outstanding discovery issues, and obviously Mr. Cosgrove is no longer in position to deal with those.
Yeah.
But we just want to get this remedied as quickly as possible.
Yeah, no, I agree. So I think I'm pretty comfortable with my ruling that within 30 days, someone has to appear from the Commonwealth.
Okay.
Whether that's the Attorney General's office or another prosecutor's office or somebody, but somebody has to come.
Thank you.
I agree with that. All right, now we're going to the other two cases, which are 23-00313 and 25-0088. I think we're on today for discovery motions on that. I know that you have filed a motion to dismiss. I'm sure Mr. Cosgrove hasn't had a chance to respond to that because it was filed within the last week.
We've had some discussion about that,
Yep.
Your Honor. And if the court is agreeable, we have some suggested dates. I believe that we have agreed on a filing date of a non-court date, non-appearance date, but a filing date of October 27th for the Commonwealth to file a response to the motion. And then I believe that both defense counsel and I would be available if it suits the court on either November 12th or November 14th to hear argument on the motion.
Margaret, what is the court schedule like for those days? With Walsh? So it's going to have to go through the regular course. Give me a date later in the month.
I think December.
Yeah, because the Walsh trial is going to start, and I think October 20th, and that will take care of this session for a while.
Is October 20th work?
No, we're talking about Mr. Cosgrove having the hearing later in the month of November. The filing date's fine.
Right, so
Later in November, Your Honor?
Yeah.
They didn't think they were going to be available till December.
yes, I mean, the
Oh, is it-
following week is Thanksgiving week.
Yeah, okay, then go into the first week of December.
Any day but the 4th.
Well, that suits me because I can't come on the 4th. So,
The 5th, okay?
Friday the 5th?
Yeah, does that make sense? All right.
Is it
Okay,
no-
so Friday, December.
Non-evidentiary motion to dismiss?
Correct.
Yes, I think it's non-evidentiary at that point. There's a prayer in the motion for an evidentiary hearing, but I assume the judge would make a decision as to whether or not to grant that based on the argument on the 5th.
I'll be at 2 p.m.
Okay, what else do we have? Do we have any?
There are two other matters, Your Honor, that I'd like to raise with the court. One is a motion for a protective order for certain investigative materials. I have just...
Is this the Brady list?
Yes, it relates to the Brady list.
Yeah.
I have just served the actual motion. The attachment was previously provided to the defense, but I believe Mr. Bradel wants to, is okay with taking it up today and wants to be heard briefly on it.
Yeah.
And I'll rely on my written submission.
Okay. So what we have before us is a motion for protective order relevant to certain internal investigatory materials, and that has been presented today by Mr. Cosgrove. Mr. Bradel, go right ahead.
Thank you, Your Honor. As the court will certainly remember, we maintain our objection about public materials,
Right.
about public officials, that, the risk of embarrassment, et cetera, is not a grounds to, hide something from the public. And, a lot of this stuff, the trend has been in the last few years to make police misconduct issues publicly accessible. So, Mr. Kearney shouldn't have less rights than everybody else out there. There's no First Amendment exception for Aidan Kearney, that he can't have things that the public can have. So this is one of those issues where, you know, we maintain our objection that there's no reason to impound these items. And the stated reason that, oh, Mr. Kearney might talk about these issues is not a ground, and it fits under the rubric of public officials' misconduct should be out in the public sunshine, and that's that. So it's not a ground to say, well, Mr. Kearney's going to talk about it. And so it's a simple analysis that the public interest should prevail here, and Mr. Kearney should be included in that and get the benefit of that.
Okay.
So there's no grounds. Thank you.
Gotcha. Okay, what else we got? Anything, Mr. Cosgrove?
I just have one more thing, Your Honor. Judge Rayburn, quite a while back, I want to call the court's attention to this, even though I'm not going to be in the position of litigating it. Judge Rayburn, quite a while back, gave Ms. Gattani leave to file pro se motions with the court. About 3 days or thereabouts after I became aware of my need to withdraw, there was a release of a link to Ms. Gattani's cell phone extraction on the internet, which raised a number of issues, having litigated what should happen with this cell phone extraction rather extensively over the course of this case, raised a number of issues that I would otherwise have proceeded with a motion before the court, specifically as to whether the release by someone, and it was not directly released by Mr. Kearney, violated Judge Krupp's order. Ms. Gattani has filed a pro se motion which sets forth a factual basis for that and asks for certain remedies. I'm not sure I'm on the same page with her as to what the appropriate remedies would be or whether it also violates Your Honor's order. But I do think it raises very substantial questions as to whether there was a violation of Judge Krupp's order. And I would urge the court to take a look at it and consider whether it's worth a hearing date and how the court should proceed. And that's all I'll say about it.
Okay. Have you seen it, Mr. Bradle?
Judge, have I seen
what was filed by Ms. Gattani?
I have.
All right.
First point, Judge, if I may, is that I don't think Commonwealth Counsel is in any position to argue anything on the
I think he is. I think he's would agree with that. So what I'm going to suggest is that should probably be put over to a date where there's a new prosecutor here. I agree with you on that. Sure. I think Mr. Cosgrove has correctly moved to withdraw on that case based upon the circumstances. And I think that a new prosecutor comes in, we'll take a look at it, and then make a determination.
Sure.
Okay.
And I don't want to take a lot of Your Honor's time on this, but just so Your Honor is aware of our position, is that Ms. Gattani keeps filing these motions with the court that are creating a serious risk of denying Mr. Kearney of a fair trial, prejudicing him, prejudicing me, prejudicing Mr. Betterow to the court, to the public. And these things keep getting filed by a third-party litigant. There's no privilege in Massachusetts on the part of a third-party litigant to be asking for things like she's asking for in this motion, suppression, a fine, other relief. You know, this is outrageous. And we're going to ask in writing when there's a new prosecutor.
Yeah, why don't you do that? Why don't you respond?
Because we've just had it with this. It's going to prejudice our rights to a fair trial on behalf of Mr. Kearney. She can't keep taking pot shots with the court. Your Honor has to read this stuff. You know, it should be stricken. It shouldn't even be accepted is our position.
All right. So I will then see you back, or someone will see you back on whatever date that is that we chose for the hearing.
And one final thing, Your Honor, I'll put on the record that I told Mr. Bradle and Mr. Betterow that with respect to the most recent indictment against Mr. Kearney that involves him standing outside the pizza shop.
Oh, yeah, 25.
Making faces,
Yeah.
that I would provide him with the discovery by the next court date.
Okay.
And that's agreed to, Judge. That's perfectly fine. I did file 2 arraignment motions that I would just ask the Commonwealth to look at in terms of what we're looking for in terms of the response.
Okay. Sounds good. Thank you all.
Thank you, Your Honor.
Your matter is continued to December 5th at 2 p.m. Thank you.
Thank
All right. Have a nice day.
Thank you. Thank you.
If you don't have those, I'll look up.
What are
So in the 25 case, it's a motion for exculpatory discovery, that's the Grand McFarland stuff. And then there's an arraignment motion for discovery. It's really just asked for like specific things.
Okay, we probably have them.
Yeah, I saw it in the docket.
Okay, great.
But I'll make sure everybody sees.
One thing I didn't see, so your motion to dismiss, we have the memorandum with the affidavit.
Yep.
You do like just a simple motion.
Hey, folks. Great. We're gonna try to stay live on this. Gonna try to get Scott McGinnis outside the courtroom. He's got a Zoom link, so we're gonna wait for him. Try to get some footage from outside of court right now. I just gotta say, I'm bummed because it sounds like October 5th. Did anyone catch the time? Was it 2 p.m.? The next hearing? That would be a week from this Friday, which I just agreed to do the Grace Curley show. I agreed to fill in on that day. So I'm not sure I'm going to be able to stream Aiden's hearing on that Friday. I hope some other YouTubers are definitely going to cover that. December 5th. Yeah, what time? Was it 2 p.m. or was it 9 a.m.? If it's 9 a.m., I could get it started and it would work out. But if it's 2, it's going to be hard for me because I'll be just finishing up the Grace Curley show. Yeah, it sucks. Maybe some way I can stream it from there, but I don't know. Yeah. December? No, I thought they said October 5th. Did they say December 5th? I thought they said October. Oh, 12/5. Wow. Wow. So they're kicking it down the road. Okay, December 5th. Thank you for so now I'm not worried about it. Thank you. I thought they were talking about October. I was only 2 months off. All right, let me check. I'm going to drop off for a second. I want to check in with Scott McGinnis. Oh, October 5th is just the filing date. Good. Okay. So the next date is in December. That's a long time. We'll see. We'll see. This is you could tell the judge was listening today. He got their attention. Betterow definitely, as you know, he didn't speak much, but you could tell the judge was definitely listening to Betterow today and Bradel. December 5th. Wow, 2020. No, not 2026. 20. I know, right? December 5th this year. Let me check in with Scott. I'm going to drop off the screen for a second. I'll be right back. Hopefully we'll have Scott outside the court. Scott McGinnis. He's in the green room. We just brought him up on the screen. All right, I'm going to drop off. Let's see what Scott's got for us outside of the court right now.
Well, that was a lot of. I think we anticipated that the motion to dismiss would be argued in a different case. We would need more time. Of course, it was a mega motion, so it's a lot.
And they haven't responded yet.
They didn't have responded yet, so they have to respond like 30 days, and then we're going to argue it on December 5th. It sounds like so. But I think the big news out of today was that what we knew was coming, that Robert Cosgrove has tapped out of the Kearney indictments. So
Yeah, and you guys didn't object to that. So let me ask you this: let's talk reality here. In 30 days, if they haven't appointed some magical prosecutor, will the court do anything?
This case is on life support. There's no prosecutor. There is literally no prosecutor on the 2024 case. One was removed by the court for making himself a witness. Two have had to withdraw for various reasons. Alleged victim in that case is suing anybody and everybody in connection with that case. Who's taking that case? Would you?
I will not take that case.
So, look, someone has to show up, but I think also the court recognizes that because of the legal maneuvering, that district attorney doesn't even have the ability to appoint someone because they're apparently going to get sued as well by this individual. So it's a fiasco.
So Judge Doolin made it sound like I'm laying down the law here. 30 days, got to be somebody appointed. Do we really think something will come with it if nothing can happen? If nobody's appointed?
Well, something has to happen. Either dismiss or prosecute, one of the two. We have a right to discovery that's still outstanding, and that shouldn't stop because they don't have their house in order. So our position is get your house in order, and if you can't, then do the right thing and dismiss.
Yeah.
End it.
And certainly the defense is prejudiced by that. We're talking about the most recent case where you're waiting for some discovery. That now they say will be here by the December 5th latest date. What are you expecting to get? This relates to what I call the pizza case.
The window intimidation.
Yes.
So we're just reading on grand jury documents. We haven't got them yet, so we don't know what was said in there. And of course, we've seen in the other case that the grand jury is very important. That happens behind closed doors, and if there's shenanigans, we need to be able to identify them and review what happened in there and how I was indicted for witness intimidation for doing T-Rex arms Tuesday night.
But we also want to know on that, the whole case revolves around an apparent illegal wiretap out on the street. So what are they going to do about that? Are they going to charge him? Are they going to give him a break?
Was that rhetorical?
Whoever's in charge of the property.
Let's be clear about that. We asked for an investigation into that, and initially, the Canton Police Commissioner recused herself from consideration of that and kicked it over to the DA, and we filed a notice with the DA to alert them to this, and they simply haven't responded. So, we'll have to wait and see with all of that. But
let me ask about the guts of the motion. We haven't heard the reply yet or the response, and then I assume you guys have the reply. I think the strongest part of it is the misrepresentation to the grand jury. There's a lot in. So is that the key to you, or do you see something more important in the motion that supports getting rid of each charge?
But we see a lot of problems in the grand jury, disclosing evidence, relationships with people with very checkered histories that they rely on, destruction of evidence, non-disclosure of evidence, false and misleading testimony. I mean, we could go on and on if you have an hour what the problems are. But, our view is that considered cumulatively, all of this is egregious governmental misconduct, and it all ought to be dismissed. You can't have prosecutors, police officers, private civilians working at the behest or with police officers doing these kinds of things. So I wouldn't isolate it and say this is stronger than that. The whole mosaic is awful and needs to be dismissed.
But you're a good attorney. You always have to anticipate.
I have no idea how they're going to respond to this. In our view, a lot of this misconduct is indefensible. So, but that's for them to decide. I don't want to speak.
We're not giving them any ideas.
How long
come up with their own?
Mark boxed them in really well. They're boxed in, and we're very optimistic about it. As we are, they're dropping like flies. Melo's gone, Novak's gone.
there's more to come on Nello with respect to the Read witness case that's still out there to disqualify him there. So there's much more to come. We moved the needle today, kind of mostly by agreement. Again, we're stalled because the government can't get its house in order with prosecutors. So, we're gonna see where that goes.
Every time I come to one of these hearings, I walk out the same way thinking, what the hell are they doing? And why? What's the motivation?
You have to ask them.
I knew you were going to.
None of us understand.
You might have something.
I mean, I'm coming up on the 2-year anniversary of getting arrested at the bus stop, and I don't feel like we've made much progress. They've done anything. Every time we come here, like you said, we just kind of kick the can down the road. Maybe next time we'll talk about something important and discovery. And I don't know what their plan here is, but I think it's just to keep me out on bail and keep me on my best behavior, or I don't even know if they have.
The problem is when they started this case, the idea was to stifle speech as it relates to another. Didn't work out for them, and they're still doing this, and they're kind of stuck with that. As we learned earlier this week, many of the witnesses who presumably are going to testify at a trial here are apparently all about to be sued for civil rights and conspiracy violations. That's another case, other people making those decisions. But you'd like to think at some point in time that you see what happens. We have no prosecutor on one of these tonight. The whole thing is just literally on life support. This other case is kicking around. It's failing. All of this is failing. And you'd like to think at some point that they just reevaluate special prosecutor after special prosecutor after special prosecutor. That appears to be the way the sausage is made in this county. But at some point in some time, it's got to go. It's got to go. The Kearney and Read case is over. They lost. I've heard it's time to see the writing on the wall with this case. It was only brought to keep Aiden quiet, and the thing is over. It's circling the drain. And, we want this case has got to go too.
Could the state move it to another county just to keep get a clean?
I've never seen that happen where the state would move a case. I don't think it's going to. What would that tell you if a prosecutor is afraid that they can't win in their home court, that they want to go someplace else? If that's even part of the thought process, then you should just dismiss it. Maybe if they move to North Korea.
Yeah.
So you brought up a good point. Now Morrissey is his ability. So what is the option if the court?
The hell knows. The Attorney General, who has already, as you've seen in the motion again and again, has refused to get involved. Why would anyone in private practice choose to get involved in this? Look what happens. You may get sued. Look, I don't know what they're going to do. It would be foolish to even predict. It seems to me the only right thing to do is dismiss all of it. Well, they make a lot of taxpayer money, so that's their carrot. So who knows if someone is out there, the fourth or fifth person across all these cases? Are they going to make $250,000 too?
I mean, they paid about $20,000 to work one day. They paid Ken Mello at least $80,000 to. I don't know what he did, but they just literally took the money and ran. And the taxpayers are the real victims here.
When I sit there and I see all of that money going out the door, it's frightening.
That's the scandal, though, right? I mean, you have 3 special prosecutors that are now gone from this case. What does that mean? They're not DA salary. That's extra taxpayer money. And one of them got himself kicked off for being a witness. Another one bailed the day after the motion was filed, who worked with Mello. And Mr. Cosgrove, understandably, had to leave because he's being sued. But you paid for this. It's your tax money that a year and a half later has a case without a prosecutor, and all that extra money went into it. You saw it in Karen's case with all the special prosecutor fees. It's happening here. And maybe the question to ask is, why do they keep doing it? Why does it keep happening here? What's the problem in this county, and why there is such a crisis of confidence in law enforcement here? This shouldn't be happening again and again and again. It becomes a giant fiasco.
That's why all these people are here.
Well, that's what I was going to say. Is that's where you guys come in.
the media comes in and the public comes in, that's why you guys are here, because this is outrageous and it needs to stop, and, eventually you get to the ballot box, but you guys are all free to speak out now because, Aiden's not going to be the scapegoat here. Aiden's not going to be the martyr. We're going to get him out of this, and nobody should have to be in that position.
Yeah, it's coming.
Good job, baby.
Good job. Well, do it.
Can you do a picture first? And then.
No. By the way, Mark, I got an hour.
Nice to meet you. Pleasure to meet you. Nice to meet you, finally. Thank you for coming. Good. Just one.
Yeah, I know. Well, I got a couple.
So, Aiden, is this what you expected today?
I mean, basically, yeah. I was, maybe we would get into the motion to dismiss, but I was worried he's gonna need more time. It was an easy motion. Whatever. 3 more months, just kick the can down the road.
Exactly.
Mark promised you'd be the umbrella holder for that.
Yeah, I'm like the front of the ball.
Where are you going? Okay, where's that? Oh, he's walking. Okay. In the registry. I'll drive off. Let's go. Oh, yeah. So will you come to?
Thanks, guys.
Sure. Yeah.
I got it ready to go.
Why not, right? Guys, thanks, Steve. All right, guys, thanks for being out here in the rain. Thank you so much, Tim. All right.
Starting to get wet out here.
Thank you so much for doing it.
Yeah.
Oh, I am. There we go.
Thank you.
Yeah.
We'll talk soon, but if you're not going.
All right, Mike. Phone's getting wet. I'm gonna shut this down. All right.
Thank you so much. Have a great night. That was Scott McGinnis. That was great. I want to thank him for doing that for us. It's a little rainy out there. The connection wasn't that great, but we got the audio. And it wasn't perfect, but it was better than some other times we tried it, and it was good enough for me because I got to hear more Bettero. I got to see more Bettero. I got to see the crowd. That was very nice. Thank you so much for doing that for us, Scott McGinnis. I want to thank a couple new members today, Tamara and Heidi. And I want to thank our moderators. I want to thank Scott McGinnis, of course. And I want to thank MJ, Jeno, Sarah, and Stephanie. And I think I'm going to replay this a little. I think I'm going to take a break here and maybe come back a little bit later if I feel like it and just replay court, listen to it again, watch it again. I'd just like to do that. Maybe talk more about it. We'll see. Tomorrow night, I have a big show. I got to make sure I email her right now, actually. 6 p.m., we have a retired judge who's going to discuss Kelsey Fitzsimmons. She's a family court retired judge in Massachusetts. She's going to be on the show first time on The Young Jerks. Carol Erskine, retired judge in Massachusetts. We're going to be talking about Kelsey Fitzsimmons tomorrow night, 6 p.m., Thursday night. Make sure you're here. Make sure you subscribe, follow, like, share, all that stuff. Please come back, 6 p.m. tomorrow night. It's going to be a good show. Also, I just announced it today. I'm going back on the Grace Curley show. I'm going to be hosting over there a week from this Friday. So not this week, but next week, next Friday, I'll be hosting again over there, 12 p.m. to 2 p.m. Grace Curley show on the Howard Car Radio Network. I'm looking forward to that. And gonna have a bunch of great new guests this week as well. So and October's coming up. October 7th is the big Kelsey Fitzsimmons hearing that I hope a lot of you show up for at 2 p.m. and set. Oh, no, actually, it's a 9 a.m. Excuse me. October 7th, 9 a.m., Salem, Essex Superior Court. Wear purple. So I want to thank everyone who's supporting all of these different funds and causes and showing up, and everyone pitches in. And I also want to thank Give, Send, Go. Had a couple new donations. A $25 donation came in for the Young Jerks Defense Fund yesterday, and Dalen sent $10, and Joanne sent $20. Those are the most recent donations. We have it pinned in the chat. If you want to make a donation to support my free speech, I'm being sued for defamation. Free speech is not free. It's quite costly. Even when you're in the right, even when you want to stand up, it costs a lot of money to defend it. All right, we'll see. I may come back. I'm not sure about tonight, but tomorrow night, definitely. Thursday night, 6 p.m. It's a date. Be here. Be here. We're going to have a great show tomorrow night. If I don't see you later tonight, if I don't come back, have a great night, everyone. Thank you again, Scott McGinnis and all our moderators. Thank you to everybody watching, sharing, supporting, commenting. Everybody who's being nice out there, try to be nice to each other. Have a great night, everyone.
Ms. Heard, you just testified that this case has been very hard for you. So let's talk about that and why.
All right.
Your lies have been exposed to the world multiple times, right?
I haven't lied about anything I've been here to say.
You sat here and told this jury that the events in Hicksville started with Mr. Depp getting really upset about a woman leaning on you. Is that correct?
Yes, that's effectively what happened, yeah.
You testified that he actually grabbed that woman's wrist and twisted it, right?
And